hear you. All persons have been placed still before the Honorable. The Justices of the Appeals Court, now sitting at Boston for Fifth and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. It is my great pleasure to be sitting this morning with Justices Shin and Ditkoff, and my name is Gabrielle Wolohojian. I have a couple of ground rules to go over, and you can stand or sit, whichever you feel more comfortable in. Don't worry, it won't take too long. As a reminder, for those of you who are experienced advocates here, and perhaps something new for those of you who aren't, each side receives 15 minutes to argue. We do not permit rebuttal, so do not reserve time for rebuttal because we won't be able to allow it. The yellow light on the podium comes on about a minute and a half before the end of your time. That's to give you a heads up that your time is going to expire. We try, but this is not a promise, not to ask questions during that minute and a half, so you have a chance to wrap up your argument as you'd like. When the red light goes on, your time is genuinely over, unless you are in the middle of asking a question or if the panel has additional questions. You may structure your argument in any way you wish. However, I tell you that the panel has read your briefs, and if not all of the appendices and other materials, a large portion of them, and at least all the parts that they believe are relevant. So you don't need to feel like you need to use any part of your 15 minutes to educate us on the background of the case. However, as I said, you are free to construct your argument in any way you wish. I've been told that I need to wait like a minute in between cases. I tend to jump the gun so that they can reset the clock and the recording system. So for those of you who are planning, I'm just going to tell you that, although you do not need to hesitate in coming up to counsel table when it's your turn, when your case is called. The panel intends to take a mid-morning break after the third case. For those of you who are here for cases 4 through 6. That may change, so if you leave the courtroom, which you're free to do, just keep an eye on it in case we decide to hear a fourth case before the morning break. All right, with that, I'm going to call the first case, which is 2022 P0874, Commonwealth versus Jeffrey Vigyard. I hope I've pronounced
Vigyard.
Vigyard. Thank you very much. And Attorney Jellison, is that correct?
Oh, yes.
All right. Thank you so much, and we're ready whenever you are.
Ready when the clock goes. Good morning, and may it please the court, Eva Jellison on behalf of Jeff Vigyard. I'd first like to address the motion for pseudonym just briefly. First, I would request that the court decide this motion in advance of issuing any appeal, because Mr. Vigyard and I have to speak about whether or not he wants to withdraw the appeal depending on this motion. Second, I'm only asking that a pseudonym be used in the opinion, not on the docket. So anyone from the public could go to the docket and could access this opinion and know that it is about Mr. Vigyard, but in the way that opinions circulate around the prison, his name would not be present in one of those. And the reason I'm asking that is because the facts of this case indicate that Mr. Vigyard may be bisexual. And he knows, and I have seen as the chair of the Mass LGBTQ Bar Association, that there has been an increase in violence against LGBTQ people in the prisons, that MCI Shirley is particularly dangerous for LGBTQ people. That's where Mr. Vigyard resides.
Counselor, I'm not saying this will necessarily happen, but would it solve your client's problem if we were able to write the decision without mentioning those facts that you're alluding to?
Yes, and thank you for suggesting that. I was going to say that if the panel has other solutions for keeping those particular facts out of the opinion, I don't know if that's appropriate, that we would be interested in that, and if you denied the motion but included that in the endorsement, I think that would be really helpful.
Do you know of any case in which the relief you're seeking in this motion has been allowed by an appellate court in Massachusetts?
So in Massachusetts, there are a couple cases that seem to have, there are cases in the sealing context, there are cases that have defendants where their names were not used, but I don't know the precise reason. I couldn't tell from the opinion. So it seems like it's been a solution that's been used in Massachusetts before, but I'm not sure. And I'm not sure if it's the same context. But in the federal courts, there have been several times where a pseudonym has been used specifically to protect LGBTQ people and specifically to protect people from prison violence, and I cited those in my motion. If there are no further questions on that point, I'll move to the substantive argument.
Yep.
Thank you. So I'm asking this court, I'm going to start with the closing issue, and I'm asking this court to look at the prosecutor's argument as a whole and to assess the cumulative prejudice of the prosecutor's errors. And I want to impress that with these errors, the prosecutor repeatedly informed the jury that he had access to facts outside of the evidence that supported his case, and that the prosecution team already knew that Vigyard was guilty. And he did this by invoking the official backing of the government as the prosecutor. And these errors went to important areas of Vigyard's defense, namely the Commonwealth's forensic testing decisions and the victim's initial description of the assailant. And I'll turn to each of these errors now individually. So I'm going to start with the one that I started first in my brief, which is the following language, and it's about single sperm cells that were not tested for DNA.
Sure. So for these, it's helpful if you give us your transcript page. So
Yes, absolutely. So this is at transcript 1091.
91.
And the prosecutor says, he can talk all he wants about single sperm cells and shouldn't we have tested them, but the reality is they hold no evidentiary value. We're going to test the things that are related to what occurred, aren't we? They're not going to tell us anything, at least something that we don't already know. So this language incorporated 3 errors, and I'll start with the one that I...
all right, so if we look at it in context, what was the subject matter of the paragraph in which those statements occurred? Because the paragraph starts 2 pages earlier on,
Yes, it does.
on 89. And it seemed to me that in this paragraph, the prosecutor is addressing specific points of the defendant's closing, right?
Yeah,
so the
so-
defendant did raise this issue in his closing. And the Commonwealth is certainly entitled to rebut an argument forwarded by the defendant in closing. And let's just say colloquially, I understand this argument to be, what would have been the point? I ask you to ask yourselves, what would have been the point of testing these single cell or single allele specimens? That's not the way the prosecutor said it, but that it seems to me to be the gist of the argument. Would you agree with that?
I think it's the gist of the argument, and I think
Okay,
that
so
that's...
if that's okay, then if we agree that that's the gist, what would have been, in your view, an acceptable way of making that argument?
So an
Of
acceptable
phrasing
way...
it, of phrasing it.
Sure. The acceptable way of making that argument, first of all, is the middle of the paragraph, where he goes bit by bit and he says, you know, the single sperm cell in these sweatpants belong to someone else. Now, the jury can conclude what they want from that. The problem is...
And then he went through the bedding, and then he went through,
Yes.
he goes through
And
all those things.
that's one example.
So I take it what you're saying is that the portion you're highlighting would not have been understood by the jury as simply a reformulation of what the prosecutor had just said, but to be adding something more containing a personal opinion about the validity of that decision not to test.
Yeah, and I think, and that's part of it. That's part of the error. You know, prosecutors are not supposed to share their own personal opinions. They're not supposed to share their own personal knowledge. And the language that the prosecutor used to sum up what would have been an appropriate argument used these pronouns, us, we, something we don't already know. They hold no evidentiary value. This was cast as a personal opinion. And because it's cast as a personal opinion, the jury can't simply look to the evidence to rebut that personal opinion. It indicates that the prosecutor knows something outside of the evidence. It indicates that the prosecutor really was speculating here. He didn't know that they held no evidentiary value. He could argue that the evidentiary value would have been slim given different circumstances, but he did not know that they held no evidentiary value. And they're not going to tell us anything, at least something we don't already know. What does the prosecutor know that the jury has not, been privy to? And I think that, and the thing is, especially with this error, and I can continue with it, but this is compounded by the other errors where the prosecutor is talking about things that aren't in evidence, like the victim's statement. This impresses upon the jury that the prosecutor knows something that the jury has not had access to.
Which statement are you, now which page are you on?
You know what? I did not write down the page of this one, and I apologize. I'm happy to write a letter, but
No, that's okay.
It's cited in my brief. This is where the prosecutor says that in the victim's statement, she mentioned the fake accent.
I think you're in 68?
I
think 68 might be where you are.
Thank you, Justice Ditkoff. So this is where the prosecutor is saying that she repeated that there was a fake accent in her statement, but the statement simply wasn't in evidence. So the prosecutor shouldn't be commenting on the statement.
Well, so you assume that by statement, he means written statement, but why is that? Why couldn't it have been one of the oral statements the victim gave that was in evidence?
So the jury knew that the victim had given a statement at the hospital to the detectives, but in that same sentence, the prosecutor notes that statement. And the jury also knew that the victim gave a formal statement. I don't believe the jury knew about any other statements.
Well, she said at some point I talked to an officer or a detective somewhere along those lines, and then she said she didn't know if that happened in the hospital. Isn't that evidence that there was another statement that didn't occur in the hospital?
To my best memory, I shouldn't say. I don't remember if there was testimony about another statement. I don't believe there was. I can certainly look back and clarify. But I don't believe there was. I believe the only evidence was of the statement at the hospital and then the statement, the formal statement, but I will certainly clarify.
Do you have page 68 in front of you?
I can bring page 68 in front of me of the transcript.
Volume 10?
No, you know what, I don't have the
Okay.
page 68.
So the prosecutor doesn't actually say the word statement. The prosecutor says the word claim. So victim told you he was spoken, which is obviously a typo, right, with what sounded like a fake Spanish accent, a claim that she repeated to the detectives at the hospital. So the reason why I focus...
And I think there's more.
A claim, again, comma, a claim she repeated in her statement and on the stand.
Yes.
So
She repeated in her statement and on the stand.
how do you know what the statement it
So-
refers to?
As I was saying to Justice Ditkoff, I believe the evidence was that the jury knew about was that she talked to police at the hospital, that she gave a formal statement, and then on the stand is clear. So I think that certainly a reasonable interpretation of that would be that it was during her formal statement.
During
was
her
not in
which
evidence.
statement?
Her formal police statement that she gave at the police station.
All right, but there was evidence that she made this claim before trial, right?
Yes, she said she remembered making this claim before trial, and as I conceded, I believe
And
that
so
that
why
claim-
is this phrase not grounded in that evidence?
This phrase isn't grounded in that evidence because I think as I conceded, the detectives testified that she did say it at the hospital. But this is hard, right? Because the statement isn't in evidence, and I can't rebut the idea that, in fact, she did not say it in her statement because it's not in evidence. The prosecutor shouldn't be commenting on something that isn't in evidence.
She said that she told them. Why is that not evidence?
She said she told them at some point,
Okay,
which we have evidence that she told them
but
at the
this
hospital.
sentence doesn't read, I don't think, what you're claiming. It says, Alicia told you that he was spoken with what sounded like a fake Spanish accent, a claim that she repeated to the detectives at the hospital, a claim she repeated in her statement and on the stand.
So I
That
read it
sounds
as
to me
she-
like that sounds to me like the prosecutor's pointing to three different points in time.
Right, and I don't believe that the testimony supports that.
Okay.
She said she didn't remember when she told them, but it was at some point. But I mean, like I said, this is one of the problems. He's commenting about a statement. The only statement that we have in evidence is the hospital and the formal statement. but that
The
simply
formal
isn't.
statement and her testimony, which
Right.
is evidence.
Her testimony is
right?
evidence, certainly.
And her
certainly.
testimony is that she told the police earlier.
Yes.
So
But
that
there's
is
no
evidence.
that she repeated that over and over again, and I think by saying repeated, yes, she told them. She thought she told them at some point, sure, and we have some evidence that she told them at the hospital.
Okay, so she did, there was evidence that she told them at the hospital. There was evidence that it was in her formal statement.
I'm sorry, there was no evidence it was in her
No
formal
evidence?
statement.
Okay, and then there was evidence that she said it, obviously. There was evidence
trial,
at
of
trial.
course, of course.
So what your claim is that by suggesting there were 3 times that she said it, and in fact, the evidence only supported 2 times, that resulted in, that error was not objected to, right? So
was not. It
that
was
would
not.
be a substantial risk of miscarriage of justice from the fact that the prosecutor suggested that she said it 3 times?
So as to that, I think that assuming that you conclude that the first language is error, which was objected to, I think you can use the rest of the errors as part of the cumulative prejudice analysis, and that's what I'm asking for. I really did argue it as a cumulative prejudice analysis. And also, I would ask you guys to take a look at the prejudice standard for closing arguments, because the 4-part test includes was this objected to, is it at the heart of the case, was it cured, would it have swayed the jury? But substantial risk or prejudicial error, of course, also goes to the question of whether or not it was objected to. So those standards are a bit in tension, and sometimes as an advocate, I'm not exactly sure which way the court wants me to argue that. I use the 4-part test because it appears in more opinions. So using the 4-part test with the first error, I say that error is objected to. It went to the heart of the case. It went to these testing decisions. It wasn't cured. There was no instruction. And it would have been important because the testing decisions were very important to Mr. Vigyard's case. And then I'm asking you to add these additional errors, which I don't know would stand on their own, to that cumulative prejudice analysis. So it was very important to Vigyard's case also, and this is the statement part, it was very important to Vigyard's case that the initial description of the assailant simply did not fit him. It didn't fit him in a lot of ways. It didn't fit him in terms of body type. It didn't fit him in terms of facial hair. It didn't fit him in terms of cleanliness. It didn't fit him in terms of the cleanliness of his clothes. It didn't fit him in terms of not being able to speak Spanish, which the victim repeatedly testified to and said that the person spoke Spanish, or certainly what she thought sounded like Spanish from hearing her Spanish-speaking friends talk. So all of that didn't match Mr. Vigyard. And anything to suggest that the victim's statements were consistent, more consistent with Mr. Vigyard from the start, really affected his defense. So very central to his defense. Also very central to his defense was this Bowden defense that the Commonwealth did not test other evidence that they had noticed could have been relevant to this case, and that therefore they never found the true perpetrator. So these errors were Vigyard's defense. So I'm asking for that cumulative analysis, even if the second error itself would not stand alone.
All right, let me see if there are any further, yes.
I had one question on your argument about the restriction of the defendant's testimony, that
Yes.
he asked to have the items tested, and you present that on appeal as Bowden evidence. And I'm just wanted to clarify from you whether you think that was raised below, because the way that the discussion unfolded was the question to the defendant posed was, after receiving the information about DNA, did you speak with a lawyer? And then there's an objection in a sidebar, and the relevance that was posited by defense counsel was defendant has indicated he asked to have other DNA testing done based upon the fact that he didn't believe any of the DNA was at that scene. And then the judge points out that that would open the door to the fact that he ultimately didn't follow through on his request to have it privately tested. So that's not the same purpose that you're now arguing on appeal, right?
I mean, I took it to be a clear enough articulation that he wanted the jury to know that he had asked for this
'Cause
extra testing.
For the purpose of showing that he thought that it wasn't going to be his DNA on the other items. That's different from arguing that it's part of a Bowdoin defense.
I think that's a fair interpretation of it. I think I took it a little bit more broadly, that he was going to be arguing that, you know, the Commonwealth didn't do this testing, not just that, you know, he asked for it, it was denied, so that the Commonwealth didn't do the testing. But I think that's also reasonable.
Okay.
Joseph? No, I don't see any further questions. Thank you
Thank
very
you.
much. Attorney Greenbaum?
Thank you, Stephen Greenbaum, for the Commonwealth. I would first like to either point out a letter. In preparing, I discovered one incorrect citation to the record in my brief. Would you like me to send it in a letter or relate it to you now?
You can tell us now.
It's on page 26. In the middle of the page, it has to do with a quote about the sentence about Officer DeSantis's testimony that the victim had reported that she thought the accident was fake. And I've cited it to volume 10, page 85. It should be volume 8, page 85.
Thank you.
It sounds to me as if the court understands the Commonwealth's arguments. I think the only argument with any weight to it at all that the defendant brings has to do with that first comment by the prosecutor about what we already know. But in the context of what was going on, the prosecutor wasn't expressing an opinion. He was explaining to the jury why the prosecution team didn't test the evidence.
I think we can agree that that's not the way that argument is supposed to be made.
Your Honor, I'm really having trouble hearing. I'm
Okay,
sorry.
well,
And I don't know if I'm...
we could both probably benefit from each of us speaking up a little bit more. Can we both agree that's not the way that argument should have been made?
Well, I agree, and the term no evidentiary value, and I conceded in the brief that he clearly didn't mean that as a legal instruction, but the court informed that arguments aren't evidence. Yes, it was awkwardly said. It shouldn't have been said that way, but overall, I think the jury would not have understood this to mean that the prosecutor was saying anything other than, we know where the robust sample of sperm cells and semen came from a certain source. We just assumed that these single cells on the torso either would show us nothing or would come from the same source, and that's why we decided not to test them.
Was there evidence at trial as to the reason why those specimens were not tested?
No, I think the only evidence was that they weren't tested.
Right.
Testimony, yeah.
So to the extent that the prosecutor was trying to explain, not only did the prosecutor say they have no evidentiary value, which should not have been said, but the prosecutor also suggested the reason why that decision was made, and there was no evidence for that either, of the thinking behind the decision not to test it. The judge, the prosecutor, I think, could have fairly suggested to the jury that they could make certain inferences as to the absence of testing, maybe that if they were reasonable. But I don't know that the prosecutor can say this is the reason why that this was the actual reason.
No, that is a fair point. I can't say that, as you, I don't believe there's anything in the record in testimony on that particular issue of why. I'd like to look at the record again and submit a 16L letter because that's a good question. But yeah, I agree that in that context, it was probably out of line.
Okay, so let's just assume for the moment we were to determine that those aspects of the closing were error and that an objection to them was preserved. Mm-hmm. Can you address the prong of prejudice?
Well, the interesting thing about this, I think that argument, in fact, didn't undercut the defendant's theory. In fact, it's right in line with the defendant's theory, which was the prosecution got this DNA testing result from the semen in the hair and jumped to the conclusion, because it came back to the defendant, they jumped to the conclusion that I was the perpetrator and didn't need to do anything else. So in a sense, to the extent that the argument might have been proper, he's really saying what the defendant said. We just assumed it was him. We didn't see the need to test anything else. So in terms of prejudice, I don't see that it prejudiced the defendant's case, because it was consistent with what the defendant's theory about why it was inadequately investigated was. They just jumped to conclusions. So he's saying, we just jumped to a conclusion. So in that sense, I don't see how it prejudiced the case, really caused any prejudice to the defendant's theory of defense.
It's a weird thing when the Bowden issue is based not on what the police did, but on what...
Your Honor, again, I'm really having...
It's a weird thing when the Bowden argument is based not on what the police did, but on what the prosecutor did. It's very awkward to litigate. Did anyone really figured out a solution on how to work that?
Again, I'm not sure I understand your question.
So you have
I'm having trouble hearing.
You have a situation where the Bowden complaint is not really about what the police did, but about what the prosecution did in its decisions on what to do after indictment. And it's sort of an awkward thing to, oh, there we go.
There you go.
Thank you. And I will
It's
try to do better as well.
No, I don't think the mics were on. I think that was the problem. Now I'm getting,
Thank you.
I'm not just relying on my own voice like I used to have to. Does anyone really figure out a way of, how you effectively litigate that when the Bowden problem is the prosecution, not the detectives?
Well, I think the defendant was able to get there because I understand that the defendant did his cross-examination of one of the police officers did address, and you were aware, you were the lead investigator, and I can't cite to the record, but I know it's in there. So you were the lead investigator, you were aware these single sperm cells from her torso were there, and they weren't tested, and you never asked them to be tested. And he did that, so in a sense, to get it to the investigative part, the defendant was able to get it that way through that police officer rather than a generic prosecution team. In this particular case, as a general question, that's a fair concern. I'm not going to address any of the other issues. I don't think any of the other complaints about the alleged misstatements in the prosecutor's closing withstand scrutiny, and particularly in this case, this is this is a case in which the evidence against the defendant was simply overwhelming. And if any of these alleged errors were in fact error, it could not have changed the jury's verdict.
Let me see if
And if there are no other questions.
You don't have to answer this, but I'm curious as to why you're a special ADA.
Boy, I get that question a lot, and my glib answer is it's because I'm old. But the actual answer is that I have retired 5 years ago. And when you come back to work, you have to be and I only found this out recently. The designation special as a special employee in the Commonwealth has certain repercussions on your ethical requirements and whether you can do work outside the job on certain other aspects. It's actually an official designation for a Commonwealth employee that affects your status. And because I'm a retired person coming back, that's why I'm designated special. It has nothing to do with the quality of my work, unfortunately.
Thank you.
You're welcome.
All right, with that, the case is submitted. Thank you both for your excellent briefing in the case and your able argument, and the case is submitted. The next case is 2022 P1188, Commonwealth versus Anthony ARRUDA. No, take your time, don't worry.
Nice to meet you. Yes, good morning. My name's Rob Kidd. I represent the Commonwealth in this appeal. This is the Commonwealth's appeal from a district court judge's allowance of a motion to suppress. I know the court's read the briefs. The facts
Can you keep your
involved-
voice up a little bit?
Sure, sure.
Thank you.
Speaking a little fast, too. I know the court has read the briefs. The facts in this involve, we allege, the silent movie that is discussed in Commonwealth versus Kennedy. We have this individual, Mr. Eddy, who is a person who is known to the police, a person from whom police have seized drugs in the past. Police observe him in an area that is an area of, quote, drug activity. They see him walking on South Main Street on his cell phone, walking quickly. He walks up the street, and that's when the defendant, our defendant, comes into the scene. The defendant is walking in the opposite direction. The two men meet. I believe there's a fist bump, and then they proceed over to this sip and dip donut place on South Main Street in Fall River. At that point, they enter the shop together. They're there, I believe, for about 5 minutes. The officers are observing this activity. They leave the shop. Mr. Eddy, the other person, puts down his bag and his cup of coffee, is my recollection. And he, after putting down the bag and his coffee, he puts his hand in his pocket, as the facts say. And then that's when the two police officers converge. They ask the defendant if he has any drugs, and I believe he says he does.
So my question for you is, I have a couple questions for you. The first one is, I believe when I read the transcript that the evidence was that they knew Eddy as a purchaser of drugs.
I thought the evidence was that they had found drugs on him in the past, although I could be mistaken, and I'll take the court's representation of that.
Well, I can go look for it again, but that's what I recalled.
Sure.
I have seized illegal narcotics from a person in the past. That's what I was, and I was aware that he was drug involved. And what do you mean when you say that he's drug involved? I've seized illegal narcotics from his person in the past. That didn't suggest to me that they knew that Eddy had sold drugs in the past, correct?
Correct.
Okay.
But it is consistent with that, although it does not rule out the fact that he could have been a buyer.
It was a buyer.
But he's a yes.
And is the theory that in this case was that he was the buyer? He has 4 bags. The defendant is claimed to have numerous bags plus cash, $20. So I assumed the theory is, and not least because of the charge of distribution, that the defendant was the seller and Eddy was the buyer.
Yes, I mean, I haven't really analyzed the case in those terms because I've just narrowly focused on the facts before
But
me.
you prosecuted Eddy just for possession, right?
I don't know that that's the case. If that's in the facts, I don't know.
So let's assume that the police knew nothing about Eddy. Nothing. Would there have been reasonable suspicion on the remaining facts to stop these two?
No.
Okay, so I don't think so either, so I appreciate your candor. So I do think that the entire case, like whether you get over the reasonable suspicion bar, turns on this testimony on page 7 of the hearing, which is that they knew that Eddy was drug involved.
Not just that. They knew that he was drug involved. They knew that this was an area where drug activity had occurred in the past. And as the court remembers, they found drugs on Eddy. And there's one other small fact I forgot to put in here, and it's not too insignificant. It's that the defendant, before they go into the coffee shop, he looks around. And then they go in. And that has some bearing on reasonable suspicion calculation. And I just want to say, counsel in the ably written brief pointed out that, the idea here is that these two men go into the coffee shop, and she points out that, there's nobody in the coffee shop, there's nobody around. What I'm trying to say is there's a plausible inference that can be made that the two men went into the coffee shop they were, they went in there, there may have been nobody in there, but they conducted their transactions with the donuts, and then they exchanged the money inside the coffee shop for the drugs, and then left the coffee shop, and then that's when they, that's when the defendant, Mr. Eddy, put the bag on the ground, and then the drugs were exchanged. That's the way it would have been done logically to avoid suspicion, because otherwise they're not going to conduct a drugs transaction inside a donut shop in front of the the employees there. They're going to do it outside. So I just want to point that out.
Well, I think all we really know from the record is that is what the officers observed. So the officers didn't say, this is not a case where the officers said anything like, in my experience, they would have, two people in these circumstances would have gone into the shop and exchanged the money first and then come out. I mean, I don't know that we have any evidentiary basis for the theory that you've just argued.
I think just I think we can make a common sense observation based on our life in society is that drug dealers hide their transactions from other people, and that if there were a drug transaction, it would not have occurred inside of a coffee shop. And the other thing is,
All right, but so let's just take a hypothetical here. How did you know that what gave the officers reasonable suspicion that the defendant and Eddy did not exchange a business card?
yes, and that's what I'm getting to. I mean,
Why is it drugs what's the basis for reasonable suspicion that what was exchanged were drugs as opposed to baseball card, business card,
again, well, the fact and
$20? Maybe Eddy needs $20 and he's giving him $20.
it could be, but
Yep.
but why the easiest, and this is where I get to the court. I don't think this is speculation. Why would that occur in the awkward context of the two standing outside the coffee shop, leaving the coffee shop, and one guy having to put all his stuff down and dig into his pocket and grab a card? That kind of thing would have happened inside the restaurant where presumably you're there. You can put your stuff down.
Well, it's the middle of the pandemic. They want to leave the inside and go outside.
Well, I mean, it was a quick incident. I don't think it would have took any time or been any risk to the two men.
So how are we not veering into speculation here?
I'm just saying, I think that it seems unlikely, the scenario. I suggest respectfully that the scenario of him giving a card over, putting his stuff down outside to turn over a card that board is respectful.
I'll tell you what I think I see in the record. So by prearrangement, the police see someone they know to have been drug involved in the past, walking down the street, talking on the phone, and walking quickly. He's going in the north or south, I forget. Coming from the opposite direction is another person. It's a reasonable inference that they were meeting by prearrangement because they find each other in the parking lot of the donut shop, and they greet each other, and then they go in the donut shop. They come out with coffee and donuts. They then exchange something. The police know that one of those fellows has been drug involved in the past. And I'm struggling to figure out how there's reasonable suspicion that exchange is a crime. If it's just based on something that one of these people has been involved in the past.
Well, this prior drug-involved person is located in an area where drug activity has occurred in the past, and before going into the donut shop, the defendant's looking around. What is he looking around for with this drug-involved person in this drug area? And they're going in there and they're leaving, and then there's this awkward. I suggest it's an awkward exchange outside of the store, you know, putting the cup and the bag down in order to conduct this transaction, whatever it is, this exchange, as the officer described it, it doesn't, to me, it seems unlikely that would have occurred outside, but I know the court may think that's going too far as far as speculation, but that's my position. Those are the total sum and substance of the facts. There are cases on point, I suggest. There is the Kennedy case. I know the court's probably familiar with it. It's an old case. It's the quote-unquote the silent movie case. But that case does, the facts I suggest are quite similar, even though it's a case that is often cited at the Commonwealth sites. There you have this individual, Morales, who is a known drug, I think he's a drug dealer, maybe. Morales, anyway, I don't know that it matters, but he approaches a vehicle, he reaches inside the vehicle, and just like this case, there's an exchange of an object. And just like in this case, it's in a high crime area. I know counsel points out that there was more detail in Kennedy as to the arrests that were made there before. And then the other case I would point to that the court is Commonwealth versus Stewart. It's in my brief, it's in counsel's brief. And that's the case where there's this sort of the officers are on routine patrol, as in this case. They see a group of people go down a narrow one-way street, including the defendant. I think it's maybe 4 people. And one of those persons is a woman, and she's counting cash. And they go down the street, and then there's a huddle of these 4 people. And then at the suppression hearing, this officer testified that he saw an exchange, but then backed off and said that all he could see was the torsos of the individual. So he couldn't even tell in that case that the defendant was doing anything. The defendant was just there. The defendant, who was a person who had known to deal drugs and it sold drugs in that particular area. That's the other fact the court should know. And the court concluded that even though the defendant could not be seen to have exchanged any item within that huddle, the other facts, the fact that the woman's counting cash, the fact that the defendant was in this area before and sold drugs or whatever, that was enough to provide reasonable suspicion. So I think that's a good case for the Commonwealth.
They have no information about this defendant.
No information about this defendant as far as, no, that's correct. That's correct.
Let me see if there are any further questions. No, I think we have your argument and we have your brief. We appreciate it. If there's anything you want to add?
No, Your Honor.
Okay, thank you. Attorney Chayette?
Yes. Good morning. Thank you, Kara Chayette, for the defendant, Anthony ARRUDA. I'd actually like to start, my brother referred repeatedly to drug activity. In fact, the transcript shows that the only use of the word activity is in closing argument. The detective did not actually say that there was drug activity. If I were on that side of the podium, drawing a distinction between arrests and activity I'd be on thinner ice. But in fact, there was what the detective said was there have been drug arrests, other drug arrests, how many we don't know, in the area, how big an area, sometime in the past. We have no idea in the past. So neither the area where the detectives were conducting their routine patrol was actually specifically identified as a place of drug crimes where people get arrested. I could get arrested right here. I haven't committed a crime here. There's just a sort of a distinction there between where the crime is conducted and where the arrest is executed. And the judge didn't find, in his factual findings, credit this question of drug activity. He certainly didn't find that it was a high crime area. And I will remind the court, even though I don't need to, that in the posture of this case, the court isn't free to dig into the record to find facts contrary to what the judge found, especially where the Commonwealth isn't alleging that any of the factual findings were erroneous. But even if that weren't the case, the facts simply don't support the theories and the hypothesizing that my brother is making. Justice Ditkoff, it looked like you had a question.
No, I was just thinking about how much I would like to have a donut from Sip and Dip right now.
You know, part of the problem, Justice, Wolohojian, you were asking whether this case really turns on Eddie, and it raises this question of kind of coulda, woulda, shoulda, right? I mean, so I was thinking, it's all hypothetical. It doesn't affect this case because all we have is what the detectives did here. But perhaps if they had just walked up to Eddie and said, you're under arrest, do all the processing, and then they could have turned to my guy and said, asked him questions. But they didn't do that, right? They walk up to these two men, and it's not just, you're not free to leave. The police actually said, don't move, show your hands, Mirandize them, and then said, oh, you're not under arrest. And so I actually think that this case was litigated as a reasonable suspicion case for an illegal seizure, but it actually drifts, I think, and counsel argued it at closing, that it really leaned into heavily an illegal arrest. And so really the Commonwealth was required to do more than, but...
The same thought had occurred to me, that if they had located the 4 packets in Eddie's pocket first, before they'd done anything, before turning to the defendant, the case would have looked very different, I think, to us.
Different facts,
Right.
maybe very much a different outcome.
But at least as in terms of the way the evidence came out in the hearing, the stop was simultaneous for both of them.
It was. And just to this idea that it was awkward, the detective actually testified that there are surveillance cameras outside. I think it's at page 49, that there are surveillance cameras outside the Sip and Dip. And these guys are just standing, they put down their coffee and bag, and they just stand there while the cops approach, revolvers on the hip, lanyards. I mean, they were just standing there having a conversation. So I don't want to, I'm happy to answer any other questions. I don't want to use more time than I need. And I would just close by just saying, you know, the judge got it right. The police unfortunately jumped the gun. I do think the Commonwealth is here defending the indefensible, and an affirmance of the order communicates to the police and the Commonwealth to do better, be better. And I'll close with that. Thank you very much.
All right, we understand your argument. Thank you both. Thank you both for ably presenting your cases, and the case is submitted. My guess is we're going to take case number 4. What do you think? How do you feel about case number 4? Okay, so I just want to give advance notice that we'll probably take our break after case number 4. So if you're here for case number 4, or if Officer Spatty, if you know that the lawyers could get case number 4 outside the courtroom, perhaps word could just be passed to them that we're going to reach them before the break. Thank you. So this is case number 2022P1036, Commonwealth versus Jeffrey White. Attorney Grant, is it?
Yes, yes.
All right.
Good morning.
We are ready whenever you are.
I'm sorry?
We're ready whenever you are.
Thank you. May it please the court and Grant for Jeffrey White. Your Honors, it is black letter law that the self-defense jury instruction must be given if any evidence, even a reasonable inference, supports the defendant acted in self-defense. Here, the evidence clearly supported the self-defense jury instruction. Mr. White, the defendant, testified that Ms. Ramos, after they got into a verbal argument, broke a beer bottle and then came after him as he was going down the stairs carrying the broken beer bottle. They get to the bottom of the stairs. The kitchen counter is right there. She grabs a heavy metal dog leash off the counter, hits him on the shoulder with it, and then grabs for, reaches for, looks at a knife. And that's a distinction that the Commonwealth takes some time with, and I can address that in a moment. But the point of running through that, Your Honors, is to point out that we have an escalating series of attacks that become, first a threat and assault, escalate to a physical attack, and then we have a dangerous weapon within arm's reach of the person who's making the attack when Mr. White defends himself, pushes her away, and goes outside and calls 911. That's the series of events. The Commonwealth would have this court believe that the defendant was required to let the other person arm themselves before he could act to defend himself. That's not the law. The Commonwealth cites to no case that supports that proposition. In fact, there's a case, Ortega, that is in their brief that mentions that there's no absolute duty to retreat regardless of personal safety considerations. And of course, Harrington points out that this is a jury question if facts support that there was no opportunity to retreat. The only reasonable inference in this case, and as I said, all the inferences should be drawn in the defendant's favor. It's in the light most favorable to the defendant here, that the series of attacks happened within moments and that Mr. White acted when it was necessary for him to protect himself. Your Honors, there's no question that where the Commonwealth is relieved of its burden of proof, as it was on this case, to disprove self-defense, that Mr. White is entitled to a new trial. But to kind of add to how significant an error this was, we have evidence that the jury was seriously considering self-defense before that option was removed from their consideration. As Your Honors are well aware, defense counsel requested the self-defense jury instruction. That was denied. And then when the jury came in with 2 questions about self-defense, that was again denied to give the self-defense jury instruction. Their questions boiled down to, first, basically paraphrasing, can we consider self-defense? And second, does the assault and battery instruction explain self-defense to us? That's what those questions really boiled down to. And there was no response to that, and instead the judge just gave the assault and battery jury instruction. So we have that clear prejudice that they were considering it and it was taken from them. And then we also have the verdict, which shows that the jury who found him guilty of assault and battery, the conduct to which he admitted he put hands on Ms. Ramos to push her away, that's an assault and battery, while also explaining the justification for it. And we have the jury finding him not guilty of the one charge that rested solely on her testimony, which is the strangulation charge. So they clearly had some credibility issues with Ms. Ramos in this case. If there are no questions on self-defense instruction, I can move on to the next argument.
Well, assume we agree with you on the absence of that instruction. I'm not saying we will, just assume for the moment. I take it we wouldn't need to reach your claims of evidentiary error. Is that correct?
That's correct, Your Honor.
Do you see any reason why we should nonetheless? I mean, the Commonwealth has conceded the error with respect to the 209A order, so you've got to assume that won't be repeated.
I think, Your Honor, I don't think it's necessary to reach it. I think this is so clearly erroneous in not giving the instruction and depriving him of his defense that could be the one issue this court decides. And the other issues are also, they admit there's error in admitting the restraining order and allowing a police officer to testify that he determined who was the first aggressor at the scene and then arrested that. That's also clearly not supposed to come in. So all of this additional evidence, I think it's patently problematic and hopefully would not come in at a new trial.
In the same vein, do you have any sense on whether this error the restraining order error is rare or common in the district courts?
I don't have a sense of that, Your Honor. I think it is so clearly not permitted that I would hope that it's rare. I mean, Foreman was, I think, 1999 or the early 2000s, and that explicitly points out why a restraining order contains all these impermissible statements that are harmful and have no bearing on the defendant's guilt. So it's out there, it's clear. I couldn't speak to how often these restraining orders are coming in. I would hope that it's rare. Your Honors, if there are no further questions.
No.
Thank you. Then I would rest on my brief and I would ask this court to vacate Mr. White's conviction. Thank you.
Thank you. Attorney Borges? And I may have mispronounced your name.
No, that was correct.
Okay.
Good morning, may it please the court. Daniel Borges on behalf of the Commonwealth. The Commonwealth would respectfully ask this court to affirm the defendant's convictions. In regard to the self-defense instruction, it is the Commonwealth's position that the judge exercised his broad discretion to deny the self-defense instruction where he found that the defendant had provided insufficient evidence to meet the threshold that would require that instruction.
All right, so let's see if we can unpack that a little bit. Whether the defendant met the threshold showing, that seems to me to be a question of law, no?
Possibly, yes. I think it was my understanding that during the sidebar conversation.
The evidence is what the evidence is. The threshold for giving the instruction seems to me a legal question. So that wouldn't be reviewed for abuse of discretion. That would be error of law.
Correct.
Correct? So I'm not so sure how it is that the Commonwealth is arguing abuse of discretion as the standard of review for the absence of a self-defense instruction.
Ultimately, I do agree with you that it would be.
So we should look at the record and determine whether or not there was evidence that met the threshold. Because if there was evidence that met the threshold, then the judge is clearly wrong. We can't say the judge has discretion to then not give the instruction.
And the Commonwealth would agree that if that is found, that it would be a nearly impossible argument to argue that the defendant wasn't prejudiced by that lack of instruction. So we would agree on that.
All right. So if we were to determine on our review of the record that the defendants had met the necessary showing, then the Commonwealth would agree that in this case, reversal would be required.
Correct, yes. The Commonwealth wouldn't be able to argue that.
Right, there's clear prejudice.
Yes.
Okay.
Absolutely.
That helps me a lot.
Okay.
So I appreciate that.
Yeah.
And then can you turn to the question of the evidentiary errors? Because there were evidentiary errors.
Yes.
If we were to agree with the defendant on the first issue, I'd be very curious in knowing your answer to Justice Ditkoff's question about your sense of the prevalence that maybe in the district court that 209A, the admission of 209A orders is an actual issue, because then perhaps we should reach it.
Right.
Or, and just generally, I'd like to hear your thoughts on whether we would need to reach the evidentiary issues were we to agree with the defendant on the failure to give the instruction.
So, like co-counsel, I'm not exactly sure how often it happens across the state with the 209A orders. I know I found a few unpublished cases where this court had held that the admission of the unredacted 209A, it didn't, there wasn't a substantial risk of miscarriage of justice, but still it was error. So, from that case, I can see it's happened before. I don't know how often it happens. I do think that it could be beneficial to be addressed, because I think it is clear error that the district courts would benefit the judges knowing this can never come in. I think
it's
hard,
unredacted.
Exactly. I think it's hard to argue around how that wouldn't be prejudicial to a defendant.
What about the officer's testimony that he determined the defendant was the aggressor? Is that something you think we should reach?
I think in terms of this case, it wouldn't be necessary. I don't think if a new trial was warranted, I don't think that same testimony would be elicited if it was found to be in error. I think the police officer...
You don't perceive that to be an issue that comes up?
Correct.
I mean, it wasn't elicited here. It was a non-responsive statement, right? It wasn't elicited here. It was just something the officer said without being asked, right?
I think, yeah, the officer was just giving his narrative of what occurred at the scene, and he concluded with, after hearing both the defendant and Ms. Ramos's version of events, after witnessing both of them, after going inside the house, that he determined that Mr. White was the aggressor, and then...
Right. He could have testified that he could have testified, I arrested the defendant.
Right.
Right? But he can't give his opinion on who was the aggressor.
Right.
I think especially in a case where there's conflicting evidence on that.
Sure.
Otherwise, the police officer is in essence opining on making a credibility assessment in place of the jury of the evidence before them.
Right, yes, I agree, yeah, the statement was made in error.
Yeah.
It's just a weird answer to what did you do next? I came to a conclusion. No, what did you do?
Yeah, definitely probably was made an error. Are there any other questions about any of the evidentiary issues or anything like that?
No, but I do have a homework assignment for you. I would like to see the photos that were Exhibit 1.
Okay.
And on Exhibit 3, we only have the victim's 911 call, not the defendant's.
Okay.
And I wouldn't mind hearing that as well.
So the photos, you said you only had the defendant's 911 call?
At least on my iPad, that's all I've got. We only have the victims,
We only have the victim's 911
not the
call.
defendants. And I suspect you'll have an easier time of getting that
Sure,
together
it should be somewhere.
than your
Yeah,
friend.
definitely. Okay. Are there any further questions?
No, seeing none, thank you. Thank you both.
you.
And the case is submitted. The next case, and for those of you who are waiting ahead. Okay. A stray pencil. That's about as exciting as a mishap gets up here, let's hope. The next case, and then after we have this case, we're going to take our morning recess, which will last about 10 to 15 minutes. But the next case is 2021 P0590, Montalvo versus Montalvo. And I would remind everybody, counsel, you absolutely may come up to counsel table. I would remind everyone that the case is partially impounded. So if we can avoid using names is what I assume is the impoundment is for, or no?
I think it's the financial statement.
Maybe it's the financial statements only. So you folks probably know better than I do what the basis is for the impoundment, so let's just avoid saying it in open court. And Attorney Waller, am I correct?
Yes,
Great. So we're ready whenever you are.
thank you. Good morning, Your Honors, and may it please the Court. My name is Brian Waller on behalf of the appellant, Jose Montalvo.
You may want to adjust the microphone, and also just remember to keep your voice up.
Certainly, thank you. So we believe this case can be organized, if you will, into two large areas. One is the contempt analysis, which requires a clear and unequivocal order, a clear and undoubted disobedience, and clear and convincing evidence of that, of both of those. And then there's the award of attorney's fees that must be reasonable, and the husband must have the ability to pay. The reality is, at this point, the only relief available to the husband is an adjustment to the award of attorney's fees. This was the primary asset when the parties were divorced. The parties, it was ordered to be sold and the proceeds divided equally. As a result of this contempt proceeding, the husband walks away owing approximately $6,000 as a result of this order. Now, we believe there's issues on the contempt analysis that the underlying order is not clear and unequivocal as required. And we also believe that there's not clear and convincing evidence that the husband disobeyed that order clearly and undoubtedly.
Well, the judge credited the special master's reports. Why is that not sufficient to support the contempt finding?
So it may, honestly, it may support a contempt finding regards to the regarding the order to sell the home forthwith.
Exactly.
And there's the question of what does forthwith mean? Here, the husband filed or notified DHCD of his intent to sell on September 11th, which was, I believe, the day after he filed a motion for relief from the divorce judgment that was denied.
But it's not just taken step by step, right? There's a whole subsequent history that the judge could look at too. And if you do a step immediately, but then you retract that step repeatedly, which is what the evidence could be construed to show, why wouldn't that permit the judge to find that he had not complied with the divorce judgment's requirement that it be forthwith?
So the findings don't explain which part of the delay was attributed to the husband.
But the judge credited the special master's report, and the special master's reports do.
To an extent, there's a large gap from September 11th through October 29th, I believe, in which there's no evidence in the record as to when husband was given the forms that he needed to provide to DHCD.
But the judge says, defendant halted the sale process on December 31st, 2019, and again on February 3rd, 2020, while attempting to obtain finance for another home. And then on June 5th, 2020, defendant, contrary to the clear of this court, informed DHCD that his compliance with the court's order regarding the sale of property is contingent on him finding and obtaining financing for alternative housing. Aren't those three examples of not acting forthwith that the judge found?
Yes, so one of those was the death of his father. The other was his complaint for modification. And I forget the third.
On June 5th, he tells DHCD that he's not selling unless he gets a new place,
Yeah,
which they take as withdrawal.
I think the big factor here is the totality of the circumstances. He is the custodial parent. He's has two teenage boys that are enrolled in Westboro High School and involved in extracurricular activities. If he's no longer able to live in this low-income home, those children lose stability.
I mean, he may have good reason for disobeying the judge's order, but is that really a defense to contempt that the judge's order was really foolish?
No, and we would concede that there is a hard line there, that a violation is a violation.
Right, he can come back to court and seek relief.
So he attempted to seek relief, and that was foreclosed, pardon the phrase, by the judge, stating that she had no ability to modify the divorce judgment when in fact she did. And the husband did not appeal that, and we concede that there is no appeal of that. But I believe it shows that he made a good faith attempt to comply with the order, taking into account the care of the children. And he was not receiving child support or was receiving reduced child support. The wife was in the process of attempting to reduce the child support further. The judge found his income to be credible. That was, I believe, $600 a week or thereabouts, including the reduced child support that he had been receiving. So based on that, he would have had to find alternate housing in a market during COVID, and this was, March through June of 2020 when
How
COVID
is
was
that
just
relevant to the contempt? Are you arguing inability to comply?
Yes, to some extent, but there's different periods of the delays.
Yeah, so can I ask you about that?
Sure.
So the judge finds him in contempt on July 21st, 2020, right? And in that order, she says the court orders him to sell the house without any contingencies, and then says the court may assess further fees and sanctions for failure to comply with this order. How do you read the ultimate decision that the judge issued? Do you see those fees and sanctions to be for failure to comply with the judgment, or is it in part for failure to comply with the July 2020 order?
I would say it's a combination of both. And in our view, he complied with every order after July 21st. He signed a order with a buyer that was identified and approved through DHCD.
Why do you say it's a combination of both? Because she ordered him to pay all of the master's fees?
Correct, which date back to September of 2019. Because the
How much,
master was appointed.
what, do you know what the breakdown was in the master's fees before July 2020 and after, percentage-wise?
I do not have that.
Okay.
But I could provide that.
No, that's all right.
And the judge's order or judgment actually excludes any discussion of the August order, which voided the purchase and sale agreement that he had executed with the eventual buyer. The judge found that she was not a bona fide purchaser because it happened to be his significant other, which was fortuitous.
Well, I don't know that that was the reason, because again, she credited the special master's report, and the special master had offered an opinion that it's not a bona fide purchaser because it was undisclosed that that your client was subsidizing her in order to get her to qualify, which she otherwise would not have to purchase the house.
So that statement regarding the credit to the buyer is actually on the purchase and sale agreement that was executed. It does state that the buyer will be credited from husband's share of the proceeds. But that necessitated, that August order necessitated an appeal to the single justice, which ultimately reversed the judge's order, reinstated or...
So I had a question about that. Was the information about the husband's subsidy of the purchaser before the single justice?
No, because I don't believe that was an issue at that time.
It was not yet known that the husband was subsidizing the purchaser?
And I don't believe the June or July purchase and sale agreement was part of the record. So I believe it was just the representations of the special
So they
master.
only knew the relationship, the personal relationship. They didn't know the financial details of the deal.
That's possible.
Okay, let's assume for the moment, just for the sake of argument, that we were to find that the judge did not abuse her discretion in finding your client in contempt. Okay, let's just get past the first part, if we may, because I'm trying to figure out what you're asking us to do. And so can you address that scenario? If we were to find that judge did not abuse her discretion in finding your client in contempt, I take it that you're arguing that there's some error with respect to, I mean, you're not arguing that there's an error that in allocating 50% of the proceeds to each party. You're not arguing that he's responsible for some portion of the master's fees. I take it, I don't even see that you're arguing that there's an abuse of discretion in the amount of attorney's fees awarded as amended. I didn't see any basis that in the record that you had challenged the amended amount of fees. And so, okay, go ahead. Am I wrong on that last piece?
I believe that we challenged the reasonableness of those fees in that they included all fees after the July 21st order, which we believe should be attributed to the wife, because after that date, the proceedings were extended solely because of her request to void the agreement. And the judge warned the wife at that time that, this was only going to serve to extend the proceedings. And if the wife's goal was coercive, as civil contempt should be, then the sale of the home should have been her final goal. However, the goal shifted to be punitive and to prevent the sale to his significant other, which ultimately benefited the children and allowed them to remain in that home and remain in the Westboro schools. So it did, from that angle, work out for the father, but he lost his ownership interest in it, and
So in your take, what would be the net result?
So I believe, and I don't have the numbers actually in front of me, but it would be all of the fees after, and I believe that's in the brief, all of the fees after July 21st, 2020 would be the wife's responsibility, including all of the master's fees after that date.
All or 50%?
All of the master's fees after 7/21, as well as 50% of the rest of the master's fees up until that date.
All right, I don't understand that at all, to be frank. I mean, why is it that the judge, even if we accepted your July 21st date, why is the judge outside the bounds of her discretion in allocating 100% of the master's fees to your client, given that he was in contempt?
He was, but he was in compliance as of July 21st.
So I asked about up to July 21st. Why couldn't all the master's fees be attributed to him? Why couldn't all of the wife's fees up until that date be attributed to him?
It could be.
And why would the wife be responsible for, why couldn't, I mean, the house still needed to be sold, so the master still needed to do a lot of work.
But we also believe that the master really was not able to do much. I mean, he obviously worked a lot through the process, but because of the DHCD regulations and the deed rider, the process itself was pretty much mapped out, and he did follow that process and report back to the court. However, I don't know that his actions ultimately resulted in any advancement of the proceedings, and actually almost further delayed the proceedings when he was seeking the buyer's income information to validate her income prior to approving the sale.
Has the housing authority been informed of the husband's subsidy to the woman who ultimately has now purchased the house?
Yes, they were well aware. The realtor that was assigned by DHCD was well aware of that, as well as Riko Hayashi.
The judge found your client in contempt on the second contempt as well, of the October 26, 2020 order for giving the closing credit. And you argue in your brief that he was unaware of that order when he signed the purchase and sale agreement. I know the order wasn't docketed until November 13th, and he signed it on November 5th. But did he raise the issue of notice to the judge at any point?
I don't believe that was raised in the lower court.
Okay, thank you.
If there are no further questions, I'll rest
I
my
don't
brief.
see any. Thank you very much.
Thank you.
Attorney Kathawala?
Yes.
Thank you.
Good morning, and may it please the court, as you know, Penelope Kathawala for the appellee in this matter.
Would you please adjust the microphone and also speak up?
Yes, sorry.
Thank
This is better. Yeah. With respect to the appellee, she would suggest, or we suggest, that number one, the judge's order of July 24th, non-protunct, to June of 2019 was an absolute clear command to all of the parties, not only the provision with respect to the selling of the house, but with respect to the other items, support, et cetera. Again, our suggestion is
Well,
that
let's explore that. The judgment says the marital home shall be sold forthwith, and then the next sentence tells us how it's going to be sold forthwith. The parties shall list the home for sale with a real estate broker. Now, that's not even possible, right? Parties can't do that.
that is the clear command, I would say.
But it's an impossible command. I mean, you can't list this property with a real estate broker because only DCHD can do that, right?
Well, I believe, Your Honor, if you read on, there is a whole long...
Subject to the deed restriction and the Department of Housing and Community Development regulations.
Right.
But those regulations say you can't do that.
Well, the procedure, which I do not believe, except there's an affidavit from the attorney for DCDH and the individual who runs that program, Ms. Wolohojian, is part of the docket and does explain moderately how this process is to work. Mr. is the triggering agent in this. He has to inform the department that he wishes to sell the property. That triggers the department to notify the town, and in this case, the town of Westboro. So, I mean,
I get that, but that's certainly not what the judge told him to do. The judge told him to list it with a broker. And if he and your client couldn't agree on a broker, then the special master would take over on September 1st, 2019.
Yes.
And do it.
But I can tell the court, and again, I think I refer you to Ms. Wolohojian's affidavit that is in the record. There are a number of real estate agents authorized by the department. So I would suggest to you that, I can tell you, my client wanted to use the selling agent that sold the property to them originally and helped them when they purchased that property once they won a lottery. So that was who she was recommending, and I can tell you that that is not the person who was used ultimately. So there are multiple selling agents that do this work for the department. So I'm not saying that the equivocation of, okay, well, they couldn't just pick a broker. Well, they could within the department's, but I'm not so sure. I just would suggest if you read along, she says there's a deed rider, you have to follow that. She knew the whole process because at the trial in chief, there was, it was quite a bit of testimony from the person from the department about values and how that would be done. So she was aware of that process. Maybe she should have been more specific, however.
So the judge knew that the parties couldn't list the home with a real estate broker and yet ordered them to do it anyhow?
Could you repeat that, sir?
Are you telling me the judge knew when she wrote this judgment that it was impossible for the parties to just list the house with a real estate broker and yet ordered them to do it anyhow?
Well, the judge knew they had a choice of people within the DCH's department. Did they have a choice out in the entire world? No, but there were multiple brokers.
Are you saying they're real estate agents on a list?
Yes.
Maintained by the department?
Yes. And generally, people utilize the help of the person who runs this program. Again, this Ms. Wolohojian, she seems to run that. They generally contact her, or she gives them the list, the names, and that sort of thing. So moving on, I'm suggesting there was an absolute clear command by the judge to list the property for sale forthwith. And forthwith turned into a July 2019 order with a closing that occurred in February of 2021.
What did he do to delay the proceedings after July 21st, 2020? What did the husband do to delay the proceedings after the judge entered her July 2020 order?
He continued, and again, I would refer you to the judge's procedural history.
I've looked at it, and there is a large gap. between July 2020 and February 2021.
Well, I believe if you review the master's report, he does speak to what occurred after the July.
I mean, what
20
occurred
order.
was he signed the purchase and sale with his girlfriend, which was
Right.
then voided at the wife's request, right? And then the single justice proceeding occurred.
Yes.
So what did the husband do to delay anything after July 2020?
He delayed in that he tried to get Miss Rossi, the person who was living there, Miss Rossi was living with him at the time of the divorce, through the divorce. I can tell you, just by way of a little bit of background, and when you read some of these records, you'll see, both parties, that means husband and wife, wanted that piece of real estate, that condominium.
I understand you thought the deal was fraudulent, void, right? But ultimately, that was overturned by the single justice. So my question is more specific. What did he do to delay the proceeding after July 2020?
He attempted and continued to have Miss Rossi qualified. And I believe in Mr. Donahue, the master's report, you will see that she had some trouble qualifying. She had gone to a number of lenders. I believe that's in his first report, that Miss Rossi had gone to lenders and that the closing of some attorney that was representing Miss Rossi said the closing was going to go, but there was some issues with the bank, with Cornerstone Bank. That turned out probably not to be true. I refer you to the record. I think some of it's missing, but Mr. Donahue had attempted to gain information about the ability of Miss Rossi via the bank to purchase this property. He was completely stonewalled and only learned, as you'll see in his second master's report, when he received all the closing papers. That was sometime in February. So the second report, which I can just tell you is dated 2/16/2021, he says on February 15th, he learned when the closing took place on February 12th, that it was only then he learned that Mr. Montalvo had, number one, violated the October 20th order of 2020, where the judge said all the money will be held in escrow. It was then that, actually it was from Mr. Donahue's report, that any of us learned that Miss Rossi had not qualified, so she may have been a bona fide buyer, obviously not qualified. That was something that the wife has suggested all along might be a problem, and that, as you'll see, raises a whole number of issues, but I think...
I don't really understand this. I mean, she purchased it, she owns it now. How is she not a qualified buyer? I understand she had a little trouble getting financing.
Because she wouldn't, had Mr. Montalvo not utilized his funds or money, she would not have been qualified to get the loan.
Okay, but so?
Well, there was an October 20th, 2020 order, further order of the court, and I believe one of the justices had asked my brother about that said all monies from the proceeds would be held in escrow.
And they were all held in escrow, right? And all the money was held in escrow.
Well, no, Mr.
When
Advance...
she paid, it was all in escrow, right?
No. The money, $8,000 or $7,000 some odd dollars had been already, of the proceeds, had already been advanced to
I see what you're
Ms.
saying, because
Rossi.
it never went into escrow, that amount.
No, it was credited to
Correct.
I got
was
it.
at
I
the
understand now.
closing, that credit of $7,000 some odd dollars was given to her. Had she not received that money, and that was, if you look in there, this closing was scheduled for December, wasn't going through, that's how it ended up in February. Mr. Donahue, he does not say this, but it's relatively clear from his second master's report, where he says the closing went through on the 12th of February 2021. The master, found out only by reviewing the closing papers, which he was not allowed to get, I can suggest to you. There was a big problem with...
No,
this
he
is-
says all of this. You don't need to suggest it. It's all in the special master's report, and he also says that the amount held in escrow was lower than the amount that should have been held in the escrow because the credit was taken off the top at the closing.
So just going back to, I would suggest to the court,
But in the end, I don't see necessarily where the harm is from that, because the husband agreed that even if the money was taken off the top, in the end, in the 50-50 allocation, that amount would only be put on his side of the ledger, let's say. Do you see what I'm saying?
I completely see that, but I guess I would suggest to the court that Mr. Montalvo did everything in his power to delay this so that Ms. Rossi was qualified. He's never left the house. Ms. Rossi has never left that house. And my client had no use of any of that money, and to this day...
But it seems that all the delay after August 26, 2020 is you. It seems like every bit of delay that happened after August of 2020 was caused by your client.
Well,
The husband had a purchase and sale, the person who actually eventually bought it, and every bit of delay after that was entirely caused by your client, wasn't it?
Well,
And the judge.
I beg to differ, and I would suggest again, Mr. Donahue's bill is attached to, I believe, the second master's report. And I believe that, just if you give me a moment, I can tell you what number that might be.
Well, there's certainly a delay caused by the husband in terms of the special master getting all the information that he needs, because the special master did not have information about the structure of the transaction, and it seems to me clear from the judge's order appointing the special master that the special master was to be overseeing the disposition of this property. So I don't know if that's really delay, but it certainly caused additional proceedings to be required for the special master to find those things. I actually have a different question. You don't address in your brief the fact that the judge made clearly erroneous statements of fact in the judgment. In the judgment, she said that the husband was looking for refinancing of this property, and also that, I can pull it up if I have it here, but I don't remember, but that there were statements of fact in the judgment that are inconsistent with the statements of fact in the judge's findings.
I believe, once again, if you look at Mr. Donahue's first report and then his second report, which she credited as reliable, all of that is outlined. I just draw your attention to page 145 of the...
No, but let's look at do you have a reference for the amended judgment? Sorry, I don't have it right in
It's
front
in
of me.
214. 214 of Appendix 1.
That's right, I should have remembered the page number. Yeah. So,
Are we looking at the actual judgment, Judge?
the judgment.
Yeah.
So in the disobedience, on page 2 of the judgment, it says the defendant continued to attempt to refinance the existing mortgage on said home, which indebted both parties. Now, none of that is correct.
Judge, could you just tell me what paragraph you're...
Yeah, it's on page 68
Yes.
of the
Disobedience.
appendix. It's the second sentence.
Upon the sale, are we reading upon the sale of the marital home, the master's fees being paid?
No, I'm reading the paragraph of disobedience of the prior order. The court finds that the defendant failed and refused to sell the former marital home forthwith as ordered. The defendant continued to attempt to refinance the existing mortgage on said home, which indebted both parties, notwithstanding the court's order to the contrary, in addition to attempts to delay said sale. Now, that is not, the first part of that second sentence is not correct. The defendant was not attempting to refinance an existing mortgage on this property, nor was there a mortgage that indebted both parties. And the judge's findings get the facts correct. But here in the judgment, the judge says this. What are we supposed, you don't address this error in your brief, although it was a large focus of the defendant's brief. How are we supposed to reconcile these things?
Well, first, let me address the first part of that, where the defendant continued to attempt to refinance. I believe that you will see in Mr. Donahue's master's report that he does say, and by the way, Judge, there was a complaint for modification filed by Mr. Montalvo. I believe it was in March of 2020.
Are you telling me there will be evidence that there was a mortgage on this property that indebted both parties?
No.
Okay,
No.
are you trying to tell me that there was evidence in this record that the defendant was trying to refinance that mortgage?
There is evidence. and
Okay,
you will
then
find
we'll
it-
look to find it. Thank you. Our time is over. We'll have to leave it there.
Okay, and with
All right.
respect to indebting,
And, I'm sorry, your time is up. Let me just see if there are any further questions for either of you. All right, with that, the case is submitted. We're going to take a mid-morning break of about 10 to 15 minutes, and we will return to hear the last two cases on the list.
Court, all rise, please. Court stands at recess.
All right, welcome back. The next case is 2020, oh, no, sorry, that was the last case. Next case is 2022P 1120, ERIKA McDade versus Justin Benoit. And Attorney Yanoff?
Yes.
All right, we are ready anytime you are.
Thank you. Good morning, Your Honors. My name is Warren Yanoff. I represent ERIKA McDade.
Maybe move the microphone and speak up a little bit, please.
That better?
Yes.
Thank you. This is an issue of whether Safety Insurance made a reasonable offer of settlement prior to the trial. In this case, we assert that liability was clear as of 2013. Basically, at that time, Safety and Commerce entered into an arbitration relative to the property damage and issues, and it was determined that the tortfeasor was 80% liable, and my client would have been 20% liable. That was not the case at the jury. The jury found my client not liable or negligent at all. And that continued through the trial. Safety never changed its position with regard to liability. They always felt liability was an issue to be tried. That's just not reasonable given the facts of the case.
Well, I don't know that you can say that they thought liability was an issue to be tried. They certainly thought that the plaintiff's demand and settlement was so high that it made sense for them to try the case.
I would disagree relative to that because
They didn't value the case the same way the plaintiff valued the case.
that's usually always true in personal
Exactly,
injury.
and that doesn't mean that there's been a 93A violation or a 176D violation.
Except when you think about the fact that they increased their reserves
To 40,000.
40,000.
Okay, so if they had offered 40,000, we wouldn't be here?
Possibly, but they didn't. And the case law says...
Okay, so I don't think the reserve is necessarily, right, the 100% the measure of anything.
But
The
they had-
reserve is, what is it that drives the reserve?
Usually,
I think it's an obligation to their shareholders.
well, they're trying to minimize, obviously, their exposure.
Not through the reserve. That's not the purpose of the reserve. What is it that you understand the reserve to be?
It was the amount that the adjuster had the authority, without going higher, to make an offer of settlement.
No, those are different things, I think, with all due respect. The reserve is how much the company is setting aside on a contingent basis for purposes of corporate, I'm just going to call it integrity, because they need to keep in reserve an amount to satisfy potential liabilities. That does not mean that's how much the adjuster is authorized to offer in settlement.
But I think in terms of their evaluation, notwithstanding that...
Again, I think if you look at our case law, you'll see that's not the case.
However, in terms of evaluating the case, or at least in this case, the issue, we can disagree as to value, and the case law states that they still have an obligation to make a reasonable offer, even if the plaintiff would not accept it. And I am suggesting that was never done, given the fact that their expert, our expert physician, basically said that she had a whole person impairment. We can disagree as to the amount of the impairment, but the fact is, in evaluating this claim, the life expectancy by their own supervisor indicates that that's critical. There is a difference between disability and impairment.
And Bradley testified that he did consider ERIKA's life expectancy.
I'm sorry, I couldn't hear you.
Bradley testified that he did consider the plaintiff's life expectancy in his approval of the offer.
I disagree. When the actual
Disagree that he
adjuster...
testified to that?
He said that that's a factor that needs to be taken into consideration. The adjuster herself did not take that into consideration.
Did you take into consideration ERIKA's life expectancy in this claim? Yes.
But he didn't, he was not supervising he did not oversee that, because the issue is when you deal with the actual adjuster, she specifically
He
said...
approved it, right? He's
What?
her supervisor, right? Didn't he approve the number that she offered?
Sure, he would have approved the 15, not necessarily knowing how she arrived at it. I'm saying that it's a much different situation when she doesn't factor in life expectancy for whole permanent impairment. That's a major difference. She specifically says, I was not trained to do that, we didn't talk about that, and when she makes the offer, it's not made with the understanding that life expectancy was part of the evaluation.
Was there any dollar amount attached to that difference in the evidence?
Not directly, except by our expert who said, based on all the facts, based on whole
It
permanent...
wasn't tied to any kind of diminution in earning potential or any other monetarily quantifiable reduction?
No, because
Okay,
disability...
so if that's not present, then how is the judge to assess, how is the judge to then conclude that the amount offered in settlement was too low?
Because there's a difference between the disability portion, which I would argue is probably what they were basing, as opposed to the impairment. She's 23 years old, she has maybe 60 years left, and that impairment was permanent. That doesn't mean she couldn't work.
What about Dr. Freeman testifying? I see no reason why your pain should not get better.
No, he actually further, he says specifically that it's permanent and it won't. In terms of that, he actually specifically said that it was completely permanent, and
the definition of permanency means we don't expect any improvement for over a one-year period of time. When we use the word permanent impairment, we're talking about the foreseeable future. So will this neck pain last the rest of her life? I'm not sure. And then I see no reason why her pain should not get better.
But he says that it's permanent, so by definition, it's not going to get worse necessarily, but it's not going to get any better, and she's going to...
I don't know how you can say that. I just read where he said, I see no reason why your pain should not get better.
Well,
Ultimately, what was the question for the judge to determine on the Chapter 93A/176D claim?
the issue was with liability
Is it
being...
the reasonableness of the insurer's position?
Correct.
Okay. Is that a question of fact?
It is a question of fact, however, because
Okay,
this was...
so then what is our standard of review?
Standard of review is because this was a non-evidentiary, this was submitted totally on documents, Your Honor. You have the ability, you as the appeals court have the ability to assess that de novo. You're not bound, unlike if this were testimonial evidence and things. You have the same ability.
Well, you had a trial on documents.
Correct, and you have the right to review those.
Is that a case stated? We have cases, I think, that talk about what our standard of review is. I don't think it's entirely de novo, simply because the case is submitted on documents.
I would.
There's certain
I do
embedded
cite cases in my brief.
that say that we can review a document de novo.
Says,
But aren't there some embedded credibility determinations that the judge made here? I mean, it seems to me the judge could consider the testimony. Was the testimony that was on trial, that was presented during the jury trial, was that also available to the judge, or that was not part of what was before the judge?
that was not, the judge that heard this portion was not the trial judge.
Same judges at the trial.
So it was a different judge, Your Honor. And I'm referencing U.S. Bank National Association versus Schumacher, which basically said the court may draw its own conclusions from the record. And
If you hadn't gotten the jury award, or if plaintiff hadn't gotten the jury award that she did, let's say that she was awarded $25,000, would the insurer's position, would you have a Chapter 93A claim?
I suppose technically that would be closer to reasonable. The problem is,
All right, so
the
then,
issue is,
because I appreciate your candor there, because I think that what's actually going on here is that you're asking the judge below and you're asking us to assume that the jury's award is the assessment of the reasonableness of the insurer's settlement position.
actually, that's not what I'm asking,
Okay.
Your Honor. You gave a different hypothetical. Our demands, we believe, were reasonable.
But your demands can't be the measure of the insurer's.
But we did have an expert at this point that indicated, and there was no countervailing expert that said that this case is worth $125 to $130 by any reasonable insurance company. That's what we're talking about. You're right. If the jury came back and said she was...
And the judge discredited that expert, right? So is that something we review de novo as well?
Yes, absolutely. There was no other... You have the right to review this entire
Didn't
case.
he testify that he's not basing that on any industry standards that he could identify, but on his own personal experience, opinions?
This was an individual who had 50 years of experience at various levels, wrote treatises and books. I disagree, and I think that's where I would take certainly exception to the judge, by where there was no countervailing expert relative to value. All we have is safety, which says we think the case is worth $15,000, as opposed to having an independent expert say it's only worth $50, or this was unreasonable.
What was the evidence in the trial record of the plaintiff's compensatory damages?
There was minimal.
It was like
loss
12, 15.
It was $16,000.
$16,000. So in the sense of the amount of compensatory damages, the insurance company's position was reasonable. Would you agree with that?
No.
No. Okay.
Because in order to deter, part of it is, if there was no permanent impairment, that might be closer to reasonable, but even then, it would not have fully compensated her under the circumstances, because that would go to medicals and other things. So no, even with the 16, based on that.
But I thought the 16 included medical.
It included the medical.
Yes, it's all the compensatory damages.
Correct. And all I'm saying is that, at least, and I'll speak in my experience doing personal, when you get that, it's a $15,000 offer based on a $16,000, if you will, specials, would never be reasonable when liability is not an issue. And in this case...
There was an issue of comparative negligence at the time, right? And that was supported by the arbitration finding.
Even if you accept that, if the case was worth $60,000, $50,000, and you ascribed an 80-20, you're still more than a 15, significantly more than 15. That's the problem. There's no incentive, and with all due respect to the case law gives too much credence, if you will, to the good faith of the insurance companies when, in cases like this, when they knew liability was really not an issue, didn't say, okay, we came down to 90, we can do an 80-20. There was no budging from, there was a budging from 10 to 12 to 15, but no significant thing once liability was established back in 2013. They withheld that. We only learned of that at the time of the second trial. They did not even disclose that.
Let me see if there are any further questions, because your time has expired. No, okay, I think we're going to have to leave it there. Thank you very much.
Thank you very much, Your Honors.
Attorney Austin?
Good morning, Your Honors, and may it please the Court. My name is Tanya Austin, and I represent the defendant Appellee Safety Insurance Company. Now, as you've heard, the plaintiff argues that the trial court erred in finding that safety did not violate General Laws Chapter 93A in its handling of his client's tort claim at the trial level.
Could you speak up, please?
I apologize.
That's all right.
However, the plaintiff is unable to point to anything in the record, any fact or any argument that contradicts the trial court's reasoning or would warrant a reversal of the trial court's decision here. Now, first and foremost, I think the trial court properly found that safety settlement offer of $15,000 was based on a reasonable, although incorrect, evaluation of damages. And the Massachusetts case law, as Your Honors have pointed out, amply supports the idea that an insurance company is not held to the standards of omniscience or perfection, but rather the question is whether they reasonably interpreted the information they had at the time.
I'm sorry to interrupt. Can I just ask a preliminary question?
Yes,
Do you
sure.
agree that our review is de novo?
I don't. I believe that with regard to the trial court's findings of fact, it is still the clearly erroneous standard. Even though this panel is entitled to review the documentary evidence and draw its own conclusions, I think Your Honors pointed out that there still are credibility questions looking at the statements, the deposition testimony of Mr. Amoruso, for example. The trial court made a finding of fact that he wasn't credible, and I think that is a subject to the clearly erroneous standard and not de novo standard.
The ultimate question of whether the offer was reasonable, is that reviewed de novo?
Yes, I think it is.
Okay.
So looking at what the offer of $15,000 actually represents, I think is an instructive exercise, because we have $15,000, which took into account an $8,000 PIP offset. So right there, that's a $23,000 valuation of the case.
I'm going to ask you to slow down a little. You're speaking very fast.
I'm sorry, Your Honor. I get going on these things. Looking at the $23,000, that further took into account a 20% comparative negligence assumption, which was based upon defense counsel's consistent position that there would be that 20% comparative negligence. So take that up again, that represents a full value of the case of $28,500. That's a lot more than $15,000 we're looking at. So just looking at that, you compare that to the medical bills, which were in full about $16,300, and that includes medical bills that Dr. Friedberg, safety's expert, found were not actually causally related to the accident. So that includes a full $16,300 for the medical specials, and then 3 days of lost work. It was only 3 days before the plaintiff returned to work and doing her duties and was being paid her full salary for that. And Dr. Friedberg further opined that she had a medical end result within a year of the accident, and that she only had a 3% whole person impairment. And I want to talk about the issue of permanency here, because I think it's important to emphasize that Dr. Friedberg very clearly stated that when the term permanent is used, it's a term of art. It refers to an impairment that is not going to resolve within a single year. So even if Dr. Friedberg had opined the injury was permanent, which I note he did not, he said he didn't believe it was permanent, that it was going to resolve, the term permanent would have been used in that term of art sense. So Dr. Friedberg never thought this injury was going to last the plaintiff's entire lifetime.
But didn't the adjuster in her deposition say that she took into account that this was a permanent impairment, as did the supervisor? And so she said, so she upped the offer by $3,000 in consideration of the permanent impairment.
I do not recall specifically whether she used the word permanent. I don't believe she did. I believe it was a whole person impairment that she referred to.
They speak about permanent impairment, both of them do.
Do they?
So accepting that is true, I mean, what do we do with that? Is good faith subjective or objective?
I think good faith is subjective. Good faith can be demonstrated subjectively or objectively. I think the case law clearly indicates that just saying that an offer was less than the total verdict, that's not evidence of objective bad faith. But if there were subjective bad faith, it would have to be based upon the an admission that, yes, I knew this was wrong and I still did that. And I don't think that's in the record here. Again, the term
But
permanent is a
if
term
we
of art.
have the person who made the offer and the supervisor approving the offer saying that they considered that she was permanently impaired, don't we have to accept that?
Accept that for the purposes of a good faith
Determining the
analysis?
reasonableness of the offer.
Well, I mean, I think you could certainly look at what the adjuster and her supervisor were considering to be the basis of their offer in terms of evaluating the reasonableness. But I don't think that necessarily maps onto plaintiff's argument that because they didn't consider her life expectancy number of years specifically, that makes their offer suddenly in bad faith. I mean, if they were looking at these general idea that a lifetime impairment, if they did that, would be worth however much they're saying it's worth, that's what they're evaluating. Now, whether or not they parsed out the number of years that lifetime was going to be, I don't think it's necessary to do that. I don't think it's necessary to have specific training on that issue in order to avoid violating 93A on the training or investigation point. So I think that the trial court properly noted that looking at the totality of the circumstances, the adjusters looked at all of those circumstances, they made an offer based on those, and that offer was reasonable in light of what they knew at the time. I would also point out that although plaintiff's expert, Dr. Kasparian, attributed a 22% impairment to the plaintiff, again, I mean, the court pointed out correctly that the case law says there's a legitimate difference of opinion here. There can be a legitimate difference of opinion that permits an insurance company to, rely upon their own expert. There's nothing saying the insurance company has to take what the plaintiff says at face value. Now, given all these facts, I would posit the safety's offer was reasonable, and the plaintiff does not dispute that safety relied upon their expert, safety relied upon defense counsel's recommendations and comments. Defense counsel thought the whole case was worth a full value of $25,000. And as we've just discussed, safety's valuation of the case, as represented by its $15,000 offer, was actually $28,500. So instead, plaintiff's counsel points to this question about permanency and also alleges safety mischaracterized the witness statement of Sonia Houle. Now, I think the trial court, examined that in detail, looking at what Ms. Houle actually said about when the plaintiff applied her brakes. Ms. Houle said she was may have been a little bit late in applying her brakes, and plaintiff's counsel objects to the idea that safety characterized that as saying that she may have delayed in applying her brakes. And I would say that's a distinction without a difference. There is no indication that paraphrasing indicates bad faith in any way that would make safety's offer somehow unreasonable. On the point of Mr. Amoruso as an expert, I think the trial court was correct in discrediting his opinions and his conclusions, because those opinions and conclusions, as your honors have pointed out, were not based on any facts. Mr. Amoruso didn't do any kind of numerical breakdown to support his conclusion that a reasonable offer would have been $125,000 to $130,000, and that no reasonable insurer would have failed to make such an offer. He had no discussion of life expectancy and no discussion of what her expected damages and nothing about why that would be the only reasonable offer. He actually faulted safety's adjuster for purportedly not having a numerical breakdown, when in fact it turns out she did have a numerical breakdown and had to be pointed out to Mr. Amoruso. Mr. Amoruso faulted safety for allegedly not training its adjusters and allowing them to proceed based on their experience, but he also admitted that he thought this adjuster's experience, Ms. Parsons, was 7 to 8 years, when in fact she had been adjusting claims for 23 years. So Mr. Amoruso's conclusions were based upon demonstrably incorrect assumptions, and the trial court correctly disregarded his conclusions because they had no basis in fact and were solely conclusory based on this ambiguous, an experience that he may or may not have had. On the topic of punitive damages, plaintiff's counsel and plaintiff have requested that this court award either or remand to the trial court to award multiple damages based on safety's alleged violations of 93A. And keeping in mind the statute requires for punitive damages to be awarded, there must be a showing that the violation was willful or knowing. And while the plaintiff's brief spends significant time talking about what the standard is and when willful and knowing damages are required, willful and knowing violations are required, he points to nothing that that indicates that any violation was in fact willful or knowing, simply that it was wrong. Safety's conduct was wrong, and therefore punitive damages are warranted here. But there is no discussion of how there could have been willful or knowing findings here in this case. The plaintiff's brief simply says that everyone, any reasonable person would have known $15,000 was too low to value the case. And first of all, again, it's not 15, it's 28.5. And second of all, defense counsel believed $15,000 was a reasonable offer. The trial court judge, Judge Ritter, found that that offer was not so low as to be unreasonable. And I would posit that the very fact the trial court found that
How do
safety
we know
didn't
defense
violate-
counsel thought it was reasonable?
Because I thought the offer was reasonable?
Yeah.
I may be paraphrasing. Defense counsel opined that the settlement value of the case was approximately $18,000, and that the full value of the case would not exceed $25,000. Given that we're talking about a PIP offset here, if we took
Is that an
the-
exhibit?
That, I believe that is in,
Missed
excuse me.
this.
That is, it's in the record, volume 3, page 10. That's in safety's claims notes. We're talking about what defense counsel's comments are being relied upon, and also,
I missed that.
I'm sorry, I don't have it here. I believe I cited it in my statement of additional facts in my brief. I apologize, I don't have it at my fingertips right now. But in any event, safety was relying upon defense counsel. And if we're talking, and as I was saying, I believe that the fact that the trial judge found the safety's offer was not unreasonable supports the idea that the plaintiff cannot meet their burden of proving that no reasonable insurer would have acted as safety did in making their offer. And that's what you need to prove, just a violation of 93A, not even a willful or knowing violation. So I would submit the trial court was correct in all respects. They're correct in finding that safety's offer was reasonable in light of the circumstances, correct in finding that there was no showing, the requisite showing that safety had failed to train its adjusters had not been made, and that safety did conduct a complete and reasonable investigation here. So I would submit this court should affirm the trial court's decision in all respects.
Let me see if there are any questions. You got 20 minutes of argument into 11 minutes.
Thank you.
It might be a speed record. Thank you very much for your argument. Thank you both for your able presentation of your cases and the cases submitted. The last case for the morning is 2022 P0939, SAVVAS GIANASMIDIS versus STEPHANY GIANASMIDIS. I'm positive I've mispronounced those names, and I'm going to remind counsel that the case is partially impounded. So whatever is subject to impoundment, please don't refer to it in open court. Attorney Clark?
Thank you. Good morning. Can you hear me?
Yes.
Thank you. I guess I should preface by saying that with a divorce-heavy practice as I have, a simple contract matter like this is a breath of fresh air. Despite the contentious nature of the divorce, prior to the parties' marriage in 2003, they entered into a prenuptial agreement which specified the parties' rights to property and defined separate and marital property as those items would be addressed in the course of an eventual divorce. Separate property, of course, was intended to limit the trial court's authority under Section 34 to equitably divide, and would remain with the party to whom it had been assigned pursuant to the agreement.
Let's assume that this property, off the top of my head, it's Brenner? I forget.
It's 95 Biner Street?
Biner?
Yes.
Okay. Biner Street property was not marital property at the time of the prenuptial agreement. Okay, let's just assume that for the present purposes. But I have a hard time understanding how the prenup agreement could expand the husband's interest in that property beyond what it was at that time. At that time, he had a 50% interest in the property, correct?
Correct.
All right, so are you arguing that even though he had only a 50% interest in the property at the time of the prenup, that for purposes of determining what was separate property, he's entitled to have 100% considered separate property?
Correct.
Okay, can you point to me the language in the prenup agreement that says that?
In paragraph 2.
Let's look. Give me the page number, please, so I can follow along.
I believe it's page 24.
In the appendix?
Correct.
All right, so where does it say that okay, so give me the exact language you're relying on to say that the prenup gives him more than his actual ownership interest.
The precise language refers to any other property, however and whenever acquired. That is not the exact language. If I could refer to my appendix.
I have it, sure, of course. It's on page 24. You have good memory. That refers to shall mean all legal and equitable interests in and to real and personal property, tangible and intangible, of whatever kind and wherever located, and whenever acquired and whether owned outright, or in any other manner or held in trust, other than marital property. That seems sort of like a circular definition to me, but let's just accept it. So you're saying that as of the moment that the prenup is signed, even though the husband has only 50%, the entirety of it is to be deemed separate property? Why wouldn't only his 50% interest be deemed separate property?
Because the prenup also addresses after acquired property.
Okay, but that's not my question. My question is, as of the moment that the agreement is signed.
Yes.
I don't see how the brother-in-law's, that's who I'll call it, right? The brother-in-law's interest is separate property as defined in the agreement. As of that date.
As of that date, I guess the brother-in-law's property
is just his property. It can't possibly, I mean, I'm trying to think this through. You couldn't possibly, in my view, be taking the position, assume nothing further had happened with this property after the date of the signing of the prenup, that the brother-in-law's interest in that property was subject to the prenup. Right? You couldn't possibly be taking that position, could you?
No.
All right.
And we have not.
So I guess the answer to my question, which is as of the date the prenup is signed,
yes,
the separate property is the husband's 50% interest.
As of the date of signing,
Okay.
that's correct.
And then you're saying subsequently, presumably when the husband purchases the brother-in-law's 50% interest, it then becomes entirely separate property.
It becomes, well, yes, as after acquired property.
Is that your
correct.
claim? As it's after acquired, it then fell entirely within the definition of separate property?
Yes.
Okay, even though at that point, all right, so as of that moment. So I guess your position with respect to the agreement is that you don't look purely at the point in time in which the agreement is entered into to determine what is separate and what is marital property. You take into account subsequent events.
Absolutely. And
Okay, so then that leads us.
Can I just interject one thing? Did you tell the probate judge this? I know that your predecessor argued that this October 2013 agreement meant that it was separate property. Did he also argue that paragraph 2 of the agreement meant that even if that was not the case, it was separate property for that reason?
Really, the only opportunity I had to make that argument to the trial judge was in the course of requesting a stay. But I did make that argument that, well, essentially, based on...
So the judge makes this ruling in the bifurcated judgment and doesn't address this or resulting trusts. And I'm wanting to know whether this argument, this Section 2 argument and the resulting trust argument were made to the judge before the bifurcated judgment?
I don't know the answer to that question, I'm sorry. However, I guess more specifically outline our position is that the judge did find the prenup to be valid and enforceable, and having done so, we are bound by the terms of the agreement. And the fundamental question is whether the judge's determination that this property had been quote-unquote transformed from separate to marital property constituted a deviation from the terms of the agreement. When we say
Well, so that's what I'm trying to delve into, because I thought, when I read your brief, you must be arguing that you assess whether something is separate property or marital property as of the moment in time when the prenup was entered into. But I understand that's not your argument. Your argument is that you have to follow the property through its subsequent steps, because it may at one point be separate property, it may then become marital property, it may, so that's what I'm trying to get at. And I understand you to be arguing now that the subsequent steps can make, that the agreement does not determine that in order to know whether something is separate property or marital property, we don't look solely to the moment in time when the agreement was executed.
No, and by the terms of
Okay,
of the
so
agreement,
then let's just fast forward. So it's not an error, therefore, for the judge to have considered the transfer to the wife's LLC in deciding whether or not this was marital property.
yes, that was an error.
Okay, that was an error?
That was an error, and
How can that be an error if everything you've just said is true? How can that be a legal error?
in terms of the property at the time of
In other words, if you
divorce?
can consider after agreement events to your benefit, certainly the judge can consider after agreement events that are not to your benefit. Correct?
Correct.
All right. So the judge could consider the transfer to the wife's LLC in determining whether this was marital property or separate property.
Possibly. However, the agreement, of course, defines marital property very narrowly as property, I mean, with the exception of certain carve-outs with respect to the marital home, as property that is held jointly or as tenants by the entirety. In this instance...
So is the error that it should have been considered entirely the wife's separate property as of the date it was transferred to her LLC?
We say no.
I know, but in the way that you just explained the prenup language to me, it should have been held, it should have been deemed to be the wife's separate property as of the date that it was transferred to her LLC.
That would not be within the scope of the agreement and under the...
Why?
Well, in the scope of the circumstances, this is a trustee arrangement.
All right. I'm trying to, what's bothering me is I can't understand the legal theory that you're operating on. It looks like the legal theory shifts depending on whether the particular transaction benefits your client or doesn't. Whereas I'm trying to find an understanding of I'm trying to find some uniform understanding of the contract. Because if I don't understand what you're saying the contract requires, then I'm totally at sea as to why you should prevail here. So I'm trying to, do you see what I'm saying?
Yes, I do. And
all right, so it seems to me that according to your theory, your own theory of the case, or at least your own theory of the meaning of the contract, that the transfer to the wife's LLC should have resulted under the prenup as this property being deemed separate property of the wife's.
But then by the same token, the conveyance back to the husband's LLC would have changed it back to separate property of the husband, would it not?
Perhaps. That's what I'm trying to understand, is what is the theory that you're operating on?
Really, the theory that I've been operating on since I first reviewed this matter was that that transaction was in the nature of a trust, and whereby all of the risk, all of the expenses, and all of the benefits at least flowed through the husband, and to the extent that the family as a whole benefited by ownership of the property, then that is the way that the marriage benefited. But in terms of...
What do you mean all the risk? Wasn't the wife liable on the mortgage?
Yes, but she never paid the mortgage.
But who cares? When
She had the risk.
Yeah.
And it eventually was discharged, of course, using separate property.
So there's a presumption between spouses that there is no resulting trust. There would have to be findings of intent. I didn't see those findings of intent that would create a resulting trust in the judge's findings. Am I missing them?
To be honest, I had a difficult time following the judge's reasoning. And
Possibly
she did
because...
not exactly explain the mechanics of...
I mean, possibly because we don't know whether anyone even asked the judge whether it was a resulting trust.
And again, I don't believe that that was ever argued in the bifurcated trial.
So,
Why are you arguing it now when I take it your theory is when the property was transferred back to the husband, it became his separate property again? So why is it relevant whether there was a resulting trust before that?
Well, that would be, I guess they're two sides of the same coin. By our construction, as a resulting trust, the property remained, or at least the beneficial interest in the property remained within the husband's separate property in the first instance. And I guess the alternative version is that if the conveyance to the wife converted the property from husband's separate property to wife's separate property, then by the same token...
You're making alternative arguments.
The conveyance back would...
Okay.
Yes.
well, I'd like to explore that a little, and we're going to go over. The agreement in October 2013 that the wife would deed the property back was found to be procured by fraud, coercion, and duress. So why should we believe that the deed itself was not procured by fraud, coercion, and duress?
To be honest, I have always looked at that separate agreement as, not even an attempt at a post-marital agreement, but really just a red herring. And
It may be a red herring, but I have a finding that it was procured by fraud, coercion, and duress. So I don't know why I know the deed
why the conveyance
is
back
valid.
would not have. Well, the husband liquidated separate property in order to discharge the mortgage and obtain sole title.
Another problem I have is there's a stipulation of agreed facts that says that in June 2018, Viner Street is titled in the Weiss LLC. But that is 4 years after this deed back to the husband's LLC. So what gets the property titled back to the husband's LLC if it hadn't happened by June 2018?
Well, that was simply a lack of recording the deed for an extended period.
I'm sorry, could you repeat that?
That was simply a failure to record the deed that it conveyed from the wife back to the husband.
But recording a deed doesn't affect whether it passes title. It passes title as soon as it's delivered, right?
Yes.
So if the deed's valid, it would have transferred title back in 2014, and if it was titled in the Weiss LLC in 2018, there has to be something after that to transfer the title, right?
I'm sorry, not to my knowledge. I understand that the deed was not recorded until 2018.
I get that, but why would that affect its titling?
It should not.
All right.
But the parties stipulated to that.
Yes.
All right.
you have questions? Okay, I don't see any further questions. Thank you very much.
Thank you.
Have to leave it there. Attorney Curhan?
Good afternoon. May it please the court. Dana Curhan for the wife. With me is Attorney Richard Rose, who is trial counsel. This is a very tricky and confused issue. The judge here found that the findings weren't a model of clarity, and neither was the prenup. The problem with the prenup is that it defined marital property in a very specific and narrow way, which is property that is in the name of both parties with right of survivorship. It did not address a situation where we probably have here, where property may have been transferred back and forth, and it's not clear whose title, who has title. And I think the judge just said, I can't figure it out. Let's call this, let's deem this to be marital property. But I think we get to the same result.
Isn't that wrong? I mean, if it has to either be separate property of one or another, I don't know why, I mean, this isn't Solomon's court, where you can just say, well, I don't know which it is, so I'll just split it in half.
Well, I think there are no cases saying that, you know, the agreement purported to adopt a narrow definition of marital property, and there are no cases in Massachusetts that say that they can really do that and say, you know, we don't care what the appellate courts say, we don't care what the statutes say, this is how we're going to define marital property.
Is you haven't, the wife hasn't taken a cross appeal.
No.
But, so is the wife's position that it shouldn't have been marital property, but her own separate property?
Well, that's kind of what I figured out when I was writing the brief. It probably should have been hers.
But that argument wasn't made below.
That argument does not appear.
And there's no cross appeal, so where does that leave us?
Well, I mean, I guess where it leaves us is we will take the judge's finding that she's entitled to half. But I think if we look at the prenup and if we apply the terms of the prenup, it is the result would be equally favorable to, if not more favorable to, the wife.
But if it were in fact to have been deemed separate property, you haven't challenged then the allocation of that 50-50 between the wife and the husband.
I haven't. I said in my brief, you know, we'll take the 50%. Because there's another sort of ambiguity in that the title is in the wife's name as a matter of fact and as a matter of law, but the husband also carved out his 50% interest in the initial, right. So where is the interplay?
The judge found that it was owned by the husband. That's in the findings of fact.
The judge found that the title was in the name of the husband as of after November of 2018.
Okay.
So I mean, here's the scenario.
At the transaction with the brother-in-law?
That's the recording of the deed, right?
At the recording of the deed, but the judge didn't make a finding that it was the husband's sole property, and the voiding of the postnuptial agreement, I think, takes care of that. I don't think the judge was purporting to say, yeah, he gets title.
How could it be the wife's separate property unless the judge voided the deed?
I don't think the judge necessarily voided the
back to the husband. That the judge didn't void the deed, right? So at some point, the property was transferred back to the husband.
I mean, here's the timetable. The husband said to the wife in around September or October of 2013, this is really my property. I'm going to type something up and I want you to sign it. I want you to put it in your own handwriting and sign it. And she said no, and he said, okay, fine, I'll leave you. So she did that.
Right, that's the agreement that the
Right,
judge
that's
said
the
was not
agreement.
enforceable. But at some point, the property was transferred to the husband, back to the husband.
In March of 2014, like 4 months later,
Yeah,
she executes the deed.
right.
Now, I'm not sure how you separate the deed from the agreement to transfer the property back that was voided. And that is...
Well, maybe she changed her mind. I mean, who knows? It's,
Well, I mean, I don't think she ever
Well,
took
the agreement was just saying that for purposes of interpreting the prenuptial agreement, the transfer to the wife is not going to convert this to marital property. That's different from the validity of the deed.
Well, I also think when you look at subsequent events, where in 2017 she paid property taxes on the place. 2018, I think it was March of 2018, he filed for divorce. At that point, no deed had been filed.
Why
It was
is that?
still in-
Why is that relevant? I'm
Because the
having a lot of
prenup-
trouble.
Because the prenup appears to say that as of the time of the divorce, that whoever's name the property is in is the sole owner. Now,
So they just hadn't recorded the deed, right? But
he hadn't recorded the deed,
but it
and
was
he recorded
executed at the
it.
time of the divorce.
I'm sorry?
It was the filing of the divorce or at the time of the divorce judgment? What are we talking about here?
I think it's the filing of the divorce.
All right, at that point, if that's the relevant date, they had not recorded the deed, but the deed was executed. So why, it's still in his name?
There is I believe there is a finding, and I can't tell you exactly where it is, but that as of the time of the filing of the divorce, it was in her name. Now, in November of 2018, 6 months or so after, 8 months after he filed for divorce, he then went and recorded the deed.
yeah, it seems like maybe there was some sloppiness in distinguishing both below and maybe in the briefs about the distinction between transferring title and recording the deed.
I would agree that there was sloppiness from start to finish in this case, starting with the prenup. I think the judge in this case correctly said, I don't know, she didn't explain this, and I will concede that. But I think looking at this, it's not clear.
Do you think the question of whether a particular piece of property is or is not marital property or is not separate property under the prenup is a question of fact, question of law, or a mixed question of fact and law?
Maybe a mixed question of fact and law. And I think where there's an inherent ambiguity as to, I mean, we know that certain things, certain events make property marital property, certain events make it individual property. What happens when you have something that is really not anticipated? I think the judge could look at that and say, okay, I'm going to treat this under the traditional law of Massachusetts on marital property. There were transfers back and forth, but he transferred his individual property into the marital estate, transferred it to her, and that put it into the marital estate. It is as if he had owned his own house before the couple met, and then they refinanced the mortgage, or she actually refinanced the mortgage, and she contributed financially. She had contributed financially since the beginning, and I think the judge could look at that and say, you know, this is really part of the marital estate. I don't know if there's any other way of looking at it, but again, if we look at it under the prenup, and if my brother is right that that the title becomes who has title at the time of the filing of the divorce, then I think the title technically and legally and factually, I think title was actually with the wife.
Why? Why was it with the wife?
Because
On March 30th, 2018?
if you went down to the Registry of Deeds, what you're going to find is nothing. You're going to find it's in her
Well, there
her
can be
name.
an unrecorded transfer of title.
There could be, and there was an unrecorded, or there was a record.
There was a transfer of title that has not been invalidated. There was a transfer of title in March of 2018. That transfer of title was not recorded at the registry, for sure, but that doesn't mean that title was not transferred.
The transfer of title, the drafting of that deed was in March of 2014, 4.5 years before it was recorded. Now, nobody ever told the wife at that time that the postnuptial agreement from the previous October was invalid, and I think we have to assume that she was operating under the assumption that she had to draft that deed. And, you know, keep in mind, she drafts the deed in March, and he files his first complaint for divorce in April of 2014. I think this exactly the same factors that were operating in October were still operating a few months later when she drafted that deed, when she executed that deed.
I know, but we don't have findings, so this is sort of on these points.
Yeah, I mean, I don't know. I think the judge may have been operating under the assumption that everything that happened after that, including, you know, the deeds, the execution and the recording of the deed was void.
But then she could not have found, I'm sorry, she could not have found that the property was owned by the husband.
I don't think she could have.
But she did. I mean, it's
Well-
in her findings that she lists the property owned personally by husband and through its LLC, and in that list is the Biner Street property.
She listed it, but I don't think she intended that as a statement that at the time of the filing of the divorce, that it was not in the wife's property, it was not in the wife's name.
No, but you're saying that the judge found that the transfer itself was fraudulent and void. But
Yes.
if that's the case, she could not have found that it was owned by the husband at any point.
I think she is, at the time of the divorce a few years later, I think she's saying that's whose name the property is in. I don't think she was drawing a conclusion at that point as to who actually should get it. And I think she did that later. I think she did that in her decision when she said, you know, this is really part of the marital estate. I don't think she's making a finding as to legally who owns the property. I think she's just recognizing the fact that as of that date, the property is now listed. You go to the Registry of Deeds, and that property is now listed in the husband's LLC. So I don't think that's conclusive at all.
Do you know what was argued below on the bifurcated trial?
I can't recall specifically, no. And again, I apologize. This is, you know, I take my cases as I find them, and this is obviously somewhat of a mess. It would have been, things could have been done below that would have been helpful. But still, I think we are, at the very least, the wife is entitled to half. If this case, for whatever reason, gets remanded, I think we'd make the argument that we're entitled to the whole thing.
What would be the basis for remanding? For what? What would we remand for?
For further findings.
On what?
On the deed from March 2014, on who had title at the time of the divorce, and things like that, and, you know, why the judge is calling this marital property. That all could have been explained better. I'm not necessarily asking that it happen. I think maybe what we're asking for is that the judgment be affirmed. But if the case gets remanded, I think there are things that could be clarified. Unless there are any further questions, I will leave the remaining points in the briefs.
No, thank you very much. It's an interesting case. We've been helped by your oral arguments and your briefs and the cases submitted. And that concludes our sitting today, and the court is adjourned. I want to thank our court staff, including our court officer and law clerks, and we're adjourned.
Court, all rise, please.